Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. All of our fees are based on a sliding scale, which is based on your income. That means the less you make, the less you pay. On today's episode, I want to discuss unagreed upon dispositions in a Massachusetts criminal case. First of all, a disposition is another name for a plea agreement. It's a way of disposing of your case. That means closing it out. A disposition is where you are giving up the right to take your case to trial, and you're asking the court to accept this agreement or disagreement between the two parties. The two parties being you and the Commonwealth. So, how it works is you're asking the court to accept an agreement, and what you do is if you can agree with the Commonwealth, that is the prosecution, then that is an agreed upon disposition, and that goes before the court, and it goes before the judge, and both sides are asking for the same thing. Let's just say it's probation for 1 year. That's oftentimes agreed upon dispositions are accepted by the court. It's still up to the judge to make that determination. The judge certainly has the discretion to not go along with the proposed disposition. But as a practical matter, if a case is agreed upon in its disposition, the judge will generally go along with it and enforce that agreement. If, however, you cannot come to an agreement with the prosecution as how to resolve your case, that is what's called an unagreed upon disposition. You can still bring that case before the judge, and the two sides each have their own recommendation for the court. You fill out what's called a green sheet because it's usually green, and there are three columns. There's the defense column, the prosecution column, and the judge's column. And the defense writes down what they want, the prosecution writes down what it wants, and the judge makes the final decision as to the outcome. It's also called a defendant capped plea. And the reason for that is one of the big advantages for the defense when trying to dispose of a case is if the judge is inclined to give anything more or anything worse than what the defense is asking for, the defendant has the absolute right to withdraw the plea and to put the case down for trial. So you're not locked in at that point. It's a huge advantage because you can take your chance of trying to work out something that's acceptable to you. And if the judge doesn't agree with you, you can pull it back and you can go with plan B, which is ultimately would be to take the case to trial. So what happens is on an unagreed upon disposition, the process is the same as far as the judge goes through what they call the colloquy. That means the judge asks you a lot of questions, basically putting on the record that you're giving up your right to take the case to a trial. It could be a trial of a jury of 6 persons in the district court, or a trial without a jury. That's a bench trial where the judge is the fact finder. The Commonwealth has the burden of proof beyond a reasonable doubt to prove each and every element of the case against you, that nobody has forced you or threatened you or coerced you into accepting this plea, that you're doing this freely, willingly, and voluntarily. Then at some point, the judge will ask the prosecutor what are the facts of the case, and the prosecutor will read from the police report, basically the facts of the case. On such and such a date, the police were dispatched to this location for a report of whatever the crime is, and this is what happened. And then the judge will ask you, do you agree with those facts? And you'll have to tell him or her clearly that you are agreeing with the facts. If they think that you're not fully on board or you're on the fence, they are required not to take the plea, and they would schedule it for trial. So that whole process goes through the same way, whether it's an agreed upon or unagreed upon. If it's an unagreed upon disposition, also called a disparate plea, then each side, the Commonwealth and the defense, has a chance to try to convince the judge why they should accept each side's recommendation. So the prosecution will go first and say, these facts are terrible. The defendant's record is awful, and we think he or she needs to be, sent to jail for a period of time. And then it's up to the defense to say why they want the judge to accept what's being offered. The person has a limited record. The facts aren't terrible. The alleged victim's on board with our recommendation. Perhaps there are some conditions that are being offered that would put the judge's mind a little bit more at ease, that the person would be monitored or would be receiving some sort of help through alcohol counseling or mental health counseling or whatever it might be. And ultimately, the judge makes the decision. The judge can adopt the Commonwealth's recommendation, or the judge can adopt the defendant's recommendation, or the judge can do something else, either a combination of the two or something completely different. But again, if the judge wants to give you anything more than what you're asking for, so let's say that you're asking for a continuation without a finding for 6 months, and the judge says, no, I will give you the continuation without a finding, but I want it to be for a year. You have the right to withdraw that plea and to put the case down for trial. That's why it's a defendant capped plea, because the plea can't get anything worse than what's capped off with the defendant's recommendation. So that, in a nutshell, is an unagreed upon disposition. We at Afford Law practice criminal and family law throughout Massachusetts. We do so by offering our fees on a sliding scale based on your income. So the less you make, the less you have to pay. We're giving voice in the courtroom to the hardworking men and women of Massachusetts. Please feel free to visit us at affordlaw.org. If you have any questions, I'd be happy to answer them. Please feel free to book a free virtual appointment, and I would be happy to address any concerns or questions you have about your specific case. Thank you, and we'll see you tomorrow.